Hi, I'm Bob Kenney, a partner at BSKB. Today I'm here to talk to you about litigation hold orders. Like most companies, your company likely has a policy for routine retention and destruction of electronically stored documents, often referred to as electronically stored information, or ESI, including emails and other electronic files after a certain period of time, such as 2 years. However, courts have held that once a party reasonably anticipates it could become involved in litigation, it must suspend its routine document destruction policy and put in place what is called a litigation hold to ensure preservation of relevant ESI. If a company fails to do so and becomes involved in later litigation, the penalties for the spoliation or destruction of relevant ESI can be severe. It's important also to keep in mind that just the threat of litigation can trigger the need for a litigation hold. This might include a demand letter from another party asserting patent rights, or possibly even an oral comment from a competitor at a trade show asserting possible infringement, especially if that competitor has previously sued others in the same industry. In any event, the safest course of action is to suspend the routine destruction policy as to relevant documents as soon as it appears there's any possibility that litigation might occur. As soon as possible, you should contact your attorney and request a letter outlining the scope of the litigation hold, including a description of what might be considered to be relevant ESI and who the custodians of the relevant ESI within the company might be. It's also possible you might receive a litigation hold letter from the opposing counsel defining the scope of relevant ESI to be preserved. In any case, early consultation with your counsel can help clearly define what ESI must be preserved. Also, keep in mind that the definition of ESI is broad and can include things like text messages, voicemail messages, spreadsheets, web pages, audio and video files, and blogs, in addition to emails, and can relate to ESI located on backup tapes, office laptops, thumb drives, hard drives, social networking sites, and home computers. Therefore, it is important to also get your IT department involved early in the process and make sure they understand the nature and scope of the litigation hold requirements. As I mentioned previously, failure to initiate and follow a litigation hold can result in significant penalties to a party who is guilty of spoliation. These can include the entry of default judgment against it in the litigation. For this reason, it is important to first recognize the event that triggers a litigation hold, and second, immediately discuss the scope of litigation hold with your counsel and suspend your routine destruction policy as to relevant ESI. Thanks for joining me, and I hope you learned something today. Stay tuned to bskb.com for more upcoming videos of interesting cases and other commentary on intellectual property.